client that my lawyer is going to do some magic and get me out and get me an acquittal. At the very same time, there is a tremendous amount of pressure from general public because it's always perceived by general public that a lawyer is always defending a criminal. So we are not painted in a very good way. No doubt, people have respect towards lawyers, but at the very same time, you'll always find at some point of time, you're always in bad books because you are always protecting the criminals. That is the general perception of a common man. The third and the most important thing, the media coming into picture. Any small or a big incident, right from the taluka to a state level and to the level of the nation, any incident takes place, it's widely publicized in media. And then media makes a general perception or paints a story wherein the accused is already held guilty even before he's tried. And therefore, there's a lot of pressure not only on the lawyer, but on the judicial officer who is conducting the trial. And therefore, my friends, the first and the foremost important challenge that we face is how to deal with the pressure, the considerable amount of pressure that we lawyers have to face from all the sides. And therefore, my friends, I always remember one prayer, and it helps me a lot. Some of us believe in the God the Almighty, some of us don't. Forget about the God and Almighty part of it. But then the prayer says, "Hey, Almighty, give me the courage to change the things which I can change, and give me the strength to endure and bear the things which I cannot, and give me the wisdom to know the difference between the both." My friends, here lies the key to the first challenge that we face. Now, this may be a prayer, but the sum and substance of this prayer clearly says that firstly, you need to have a courage to change the things which you can change. That's number one. Because in a trial, when you're defending an accused, no matter what the world says about that client or that accused, no matter what the media says about the accused, you have to have the courage to try and do whatever you can do for your client. Then you have to understand one more thing, that there's a lot of pressure to get an acquittal, because if you don't get an acquittal, it is understood that you are not a good lawyer. No, my friends, that's absolutely not correct. And therefore, the second part of the prayer is very important. It says, "Give me the strength to endure and bear the things which I cannot." So, my friends, you are there to conduct a trial, to put in all your might and efforts and do everything possible to see that you conduct a proper trial and do justice to your brief. It is not your responsibility to get an acquittal, or conviction doesn't make you wrong. So, my friends, you have to understand that conducting a trial in a proper way, leaving no stone unturned, is the thing which you can do, which is in your hands. And what happens after that is a thing which you cannot change, which is not in your hands. And therefore, my friends, you have to understand and train your mind to endure these things and not look at it. My friends, the last part of that prayer is very important. You have to understand the difference between the both, what you can change and what you cannot. And for that, what you require is wisdom. And that is the key to everything, my friends. When you're practicing, it's not only on criminal side, but when you're practicing as a lawyer, my friends, what is important is wisdom. I hope you must have come across so many stories from your childhood where there is always a wise person who gives different kinds of advice to different people. And what is wisdom? It's the knowledge which you get during this 3 years, 5 years course of law which you are getting, and then the common sense which you have. So the knowledge plus common sense, application of the knowledge and common sense to the fact of your case or a fact of a case in your hand means wisdom. So my friends, you need to have knowledge of law. You have to be very practical. You should have common sense, because according to me, what is law? Law is nothing but common sense, a codified common sense. So you have knowledge, you have common sense. The only part which remains is how to apply it to a particular facts of a case. And this is what we are going to talk about today. So if you can deal with the first challenge, my friends, that you don't take a pressure that you have to get an acquittal. If you deal with the first aspect, the first challenge, that you are absolutely free from any sort of pressure that you have to get an acquittal, what the media will say, what the client will say, what my colleagues are going to say. Just don't take pressure of anything. Once you are free from that, my friends, the rest of the things are very, very easy. Now, what I have perceived for this, my experience, out of my experience, for a lawyer practicing on a criminal trial, the first and the foremost important thing which he needs to do is know the truth. The truth, the truth, and the unravishing truth. That is what you have to know. Unless you know the truth, my friends, you are treading on a very slippery surface, on a very slippery path, because you don't know. You are just shooting in dark because you don't know the facts. Unless and until you know what is the truth, what are the facts of a particular case, what I feel is you can never conduct a criminal trial. So the foremost and the first challenge which a lawyer practicing on a criminal trial faces is to find the truth. Now, do you feel that what you see on the news channels, what you read in the newspapers, what you read in the charge sheet, wherein the police investigate, collect evidence, and submit in the court, that is the truth? Or what your client, if he's on bail, he comes and meets you and gives you his side of the story, that is the truth? My friends, you don't know what is the truth at all. And therefore, the first and the foremost challenge which a lawyer practicing on a criminal side is to find out the truth. Now, I may suggest a few steps by which you can find out the truth. And you might feel that if we start doing these practice, then we might not even have time to deal with one case if we spend so much of time on one particular case. But my friends, you have to understand this. This is all about experience. As you start practicing, as you progress with experience, the amount of time which you take for doing all these things, if you take 2 days, 3 days, a week for doing all these things, you might do it in 1 hour. And therefore, my friends, I feel the first and the foremost important thing which we need to do is to find out the truth. And how do we find out the truth in a particular case? And my friends, according to me, you have to understand the criminal delivery justice system. In our system, there is a complainant who goes to the police station and lodges a complaint. Now we'll come to some hard facts and certain documents also. We'll be dealing with a few provisions of law. So then a complainant goes to a police station and lodges a complaint, which is registered under section 154 of CRPC. And thereafter, the criminal law is set in motion. From that point of time, he's just a complainant, but then the state takes everything in its hands, and an investigating officer carries out an investigation of the complaint which has been lodged by a complainant under section 154 of CRPC. Now, my friends, you have to understand this very important aspect, that here is the investigating officer or a state, the complainant, who is having a considerable amount of manforce, wherein there are so many investigating officers, there are so many deputies, there are law officers who suggest what has to be done and what shouldn't be done during the course of investigation. Then there are so many other experts, the forensics experts like DNA, the voice experts, the electronic evidence. There are hundreds of them. And the state, that is the prosecution, is well equipped with all these things. And on top of it, they have their prosecutors who present their case in the court. Now, against that, what do the lawyers defending the accused have? What are the tools that they have? And my friends, except for the tool of cross examination, except for the tool of arguments, and in some cases, which rarely happens in our country, is examining the defense witnesses, I don't think we have anything. And therefore, what the most important thing is that we don't have any resources to know what is the truth. And therefore, on one hand, there is an investigating agency who is well equipped with everything. They can verify things, they can send it to some forensic expert, they can get opinion from different people, and they can create a very concrete charge sheet and collect a lot of evidence against an accused. As against that, even if you have a different story which can be supported by good evidence, you are lacking that investigating machinery. And therefore, my friends, if we compare to the criminal jurisprudence and how it works in Western countries, in USA, maybe in other countries also, where the accused also have a lot of rights. They can subpoena a witness, they can go and take written statements of witness and submit affidavits in court of witnesses in court in their support. But we don't have. If we do that, it will be like tampering with the witnesses and evidence. And therefore, I feel there has to be some SOPs by which the standard operating procedures by which we can first find out what is the truth. And if we are able to do that, my friends, conducting a trial is very easy. What I do normally, and this is how we should be sharing our experiences with each other. And what I say isn't a gospel truth. It's just an opinion, and you can always think about it. So the first step, which I think the second challenge which a lawyer deals with is to find out the truth. Now, what we have to do is we have to read the charge sheet right from the first word on the first page of the charge sheet to the hello. Can you hear me? I think I'd lost the connection.
Yes, sir. We can hear you, but I think your video needs to be kind of aligned properly. It is tilted.
Sorry, just a moment. Is it okay?
No, sir. Still it's tilted. So you can see me, I am straight, but your video is like upside, is tilted to your right. If you can just tilt it, like keep it to the original position. Yes, sir. Yes, sir. Perfect.
This
Thank
is
you.
fine.
Yeah, sir. Please carry on.
Okay. Okay. So my friends, I was on the point as to finding the truth. Now we have to understand this, that after going through the chart sheet, you have to read the chart sheet from the first word of the first page to the last word of the last page. My friends, this is very, very important. The only reason for this is that before conducting any trial, you have to know what is the case of the prosecution since beginning. And therefore, the first step towards finding out the truth is to know the contents of the charge sheet. Now you'll find the FIR, the spot of offense Panchanama, the statements, then if there are certain recoveries, the recovery Panchanamas, then if there are certain reports of any experts, then the reports of the experts, a sketch, a map of the site of incident, and this is nothing but a charge sheet. The compilation of all these documents is nothing but the charge sheet. Now, my friends, with having read this charge sheet from the first word to the last word, you have an impression of your own about the charge sheet, about the incident. And this is the first impression which you carry about that particular incident which has taken place. Now, once you are done with that, you just make the notes of this impression which you have. Then the second important thing is having a meeting with your client and get his perspective on the every aspect which you have read in the charge sheet. So if the complainant had said something in the charge sheet about the incident, you have to take instructions from your client about the same. Having done that, the next important aspect, my friends, which you need to do, the exercise which you need to do is actually visiting the spot of incident. Now it has come to my notice that most of the times, I mean, this is what I used to do. We just read the charge sheet, we form our opinion about a particular thing, and then we just go into the court and start cross-examining witnesses on different aspects. But we just don't think that if we had visited the site of incident, maybe we could have collected some more information about the spot of incident, about the actual incident. And this reminds me of my junior days. Once I was conducting a case of accident, and this accident had taken place on Bombay Goa highway. I had not seen the spot of incident. I just read the charge sheet, the statements of the witnesses, found a few contradictions and omissions, and I was very sure that I would be able to, handle that case. When I came to the court on that day, a friend of mine who was sitting beside me but just asked me, "So, what matter do we have today?" And I was just explaining to him, this is a criminal case of accident which I'll be conducting today. And he used to reside in the vicinity of the place where the accident has taken place. And he just mentioned it to me. Oh, yeah, that place. I know that place. There are two big, huge speed breakers over there. And there are many accidents which take place over there. And that, my friend, struck me immediately. That there were speed breakers near the spot of incident. Had I gone to the spot of incident before conducting the trial, I would have come to know that there were two, on both the sides where the accident had taken place, there were speed breakers. So I just requested the court, took an adjournment, went to the site of the incident, and I actually found that the spot of incident where the accident had taken place, on either side of the spot of incident, as it was a three-way junction, there were huge speed breakers on both the sides. And that gave me my defense. My friends, it was very simple that if there is a speed breaker, then obviously the vehicle has to slow down on the speed breaker with the kind of speed breaker they were. And for a vehicle to pick up the speed, again, it will take a few distance for that vehicle to cover. So obviously, the driver was not in on a very high speed at the time of accident. So my friends, this is very important to understand the importance of visiting the site of incident. The reason is, I can give you one more example in this matter, and a case of anti-corruption. A trap was laid, and the complainant was sent to verify. I'm sorry, not a trap, but the complainant was sent to verify whether the accused was making demand. So a voice recorder was put in his pocket, and he was sent to the office of the accused. Now, my friends, I just imagined the incident, but then after some point of time, I realized that from the place where they had parked the car to the place where the accused was sitting in his office, it took about a minute or two to actually walk and reach the spot where the actual incident of demand had taken place. Now, whenever there is a ECB case, there is a trap, you always find a audio recording. It's kept in the pocket of the complainant, and he goes to the accused, talks to him, discusses with him the demand made by him, and thereafter, he comes back, and whatever is recorded is heard by all the witnesses, and accordingly they verify that the demand has been made. Now the recording was for 3 minutes actually, and both ways going to the spot of incident from where they had parked the car, it took at least 2 minutes. So 2 minutes towards the office, 2 minutes back from the office, another 4 or 5 minutes would have been required. And the case was that they had switched on the recorder when at the time when they left from the car parking, and it was switched off when they came back from the car park. So obviously there should have been a recording of at least 7 to 8 minutes or more than that, and the total recording was only 3 minutes. There were no sounds of any steps taken, walking, anything, absolutely nothing. So my friends, unless I had gone to the spot and actually seen how they walked to the spot of incident from the place where they had parked the car, I would not have understood it. So in order to understand these things, you have to go to the route. You have to see the spot of incident. You have to make your own notes. And this, I think, would be the second step in going towards finding out the truth. The third and the most important, every time you do a different exercise, you talk to your client, you make the notes. You visit the spot of incident, you make your notes. Every time you do a different exercise, you will find that you are getting a different and a better perspective of the case, and you are going towards the truth. You are realizing what is the true story. So thereafter, after going to the spot of incident, you know a lot of things. Then you again read the charge sheet, and then you will realize that there are so many lacunas in the case of prosecution. Then the most important thing which you have to do is read each and every statement of the witnesses, the Punchnamas, and then you will have to find the inherent inconsistencies. Now, these are very important. Inherent inconsistencies. If you take one statement, a witness says one thing at one point of time in his statement, and another thing at another point of time in another paragraph in the same statement. This is called as a inherent inconsistency or a contradiction, which you find in the statement of one witness. Now, you take another statement of another witness on the same point, on the same point, and then you compare that statement with the first witness, and then you will find contradictions intersay among two witnesses. I will show you the very practical, theoretical case which I have, so that it is explained very clearly. But then the inherent inconsistencies and contradictions in one witness and the inherent contradictions between many witnesses, this is what you have to find out. Now, my friends, every time I'm suggesting you something, you have to make notes of all these things. After going through the statements, then you come to the actual investigation, like the Punchnamas. If there is a spot of offense Panchanama, there is a seizure Panchanama, then you will have to read every Panchanama, and then you will have to find the inconsistencies amongst them. After having found all those things, I feel you should have a last but a most important interview with the client, because by now you have gathered and you have collected so many things which you were not knowing about the case, and therefore you can seek an explanation from your client about all the aspects which you have collected during the course of this finding of the truth exercise. And then your client is going to give his own version about that particular incident. Now, my friends, from the first time you read the charge sheet till the last time you read the charge sheet, after doing all this exercise, you will have a totally different perspective of a particular case. And then, in my view, you are somewhere close to the truth. And why I keep on saying that you should know the truth is because unless you know the truth, you can just go and ask question to any witness, because it could be very dangerous for you to ask any question if you don't know the truth, because the witness will immediately come out with that truth and you will be caught, unexpectedly caught in a particular situation. And therefore, this exercising of finding the truth has to be done. Now, my friends, this is the first challenge you need to deal with, is the finding of truth. Now, what is the second or the third important aspect or a challenge which you need to do? I have realized over a period of time that in a criminal trial, chronology is the most important thing which we almost or always and almost miss. The chronology of incident is a very important aspect which you have to understand, my friends. And not only the chronology of the incident. So let us take an example that offense has been committed. Let's say an offense of murder has been committed in a broad daylight. So all the incident which are the cause or the motive for this particular incident, they are important. Then how the actual incident took place, that a complainant was standing at some place, the accused came there, he had a gun, he shot at him and fired 2 rounds of bullets, hit him, and then ran away from that spot, and then go and then went and hide somewhere or hid somewhere. All these are the chronology of incidents. So from the first incident in a particular given criminal case or a particular incident till the last incident in that particular transaction or the set of transaction, you will have to prepare a chronology of incidents, my friend. This is a map. This is actually a map. And by doing this, what you're doing is a very important thing. And you will not even realize that you have got a lot of material out of it. In the sense, let us take one case wherein there are 3 or 4 eyewitnesses, another 5 or 6 witnesses on different circumstances, which form, let us say, if it is a motive of that particular offense, why that offense took place, because there was some enmity earlier, there had been a fight earlier, then the actual incident, how it started, and thereafter, after the incident, something else happened, the 3 parts of incident. So now you divide these witnesses, the eyewitnesses and the other witnesses who form circumstances, which is the circumstantial evidence. And every witness, every incident, every place and time. So the time, place, and incident of one witness, you will have to make a note that this witness was at this particular time, at this particular place, and has done or witnessed this particular thing. Likewise, you prepare a chronology of one witness as to where he was, at what place he was, what was he doing, at what time it was, and then a chronology of one witness is prepared by you. You prepare a chronology of all the witnesses on the same point, and then you will have a totally different perspective, my friends. And that perspective is a total scenario of the whole case, because then you can realize that A witness was at this place at this particular time, B witness was at this particular place at this particular time, C witness was at this particular place at this particular time, and they were doing particular things at their different places. So you have a complete map of everything, the movement of these witnesses at different places. Now, this is a very skillful job. What I'm trying to tell you is that when you stand for cross-examination, you will need to have all these things in your head, and that will be the next challenge. So, my friends, when you have a chronology of incidents of the witnesses, you make a note of it, and then you fix a particular witness at a particular place at a particular time. Now, this is regarding the chronology of witnesses as to the incident. Now, at the very same time, there is another important thing which you have to do: the chronology of the investigation that has taken place. My friends, the investigation starts when an FIR is registered in section 154 of CRPC. It is handed over to an investigating officer. And that investigating officer, first thing what he does is goes to a spot of incident, prepares a spot of offense Punchnama. Maybe thereafter or just before that, if he comes to know who the accused is, he goes and arrests that particular accused, and therefore an arrest Punchnama is prepared. Thereafter, he goes and collects so many other things. If the accused is ready to disclose something, then a Punchnama under section 27 of the Indian Evidence Act is prepared. And my friend, that investigating officer records a statement, and then he goes to a particular place and recovers that particular thing. So then you will understand that every investigating officer moves at different places at different point of time with different officers, or maybe with the accused, and does different things in investigation. Now, my friends, this is one thing which we never even consider. What I feel is you have to have a map ready as to where the investigating officer was at a particular point of time, what he was doing, who was with him. You need to know everything about that particular investigating officer. Now, normally there is a case diary. The investigating officer, whatever he does, he makes note of all those things and submits the case diary in the court, but you are not accessible. These case diaries are not accessible to you. And therefore, you have to prepare your own case diary of the investigating officer as to what he was doing, where he had been, what he did, and fix him at a particular place, at a particular point of time, with a particular act. Now, my friends, by doing all these things, this exercise, now with experience, you will understand you can do it very easily. So now, on one hand, you have the chronology of incidents, and you have fixed the witnesses at a particular time and place doing particular things. Then you have the map of investigation, where you have fixed investigating officer doing a particular thing at a particular place, and you have all this chronology and incidents ready with you. Now, my friends, comes a provision of the Criminal Procedure Code, which is very handy. And in my experience, these documents which I'm going to tell you now, or the registers, or different sets of documents which I'm going to tell you now, these have been very useful to me, and I have seen different lawyers, senior lawyers making use of them. If you understand the provisions of section 91 of the Code of Criminal Procedure, it's very important. Section 91 of the Code of Criminal Procedure helps you a long way to go and lay your hands onto certain documents. As per the provisions of section 91, a court can summon a government officer, a public servant, to produce particular documents in his custody in the court. If you read the provisions, it will be very clear what all documents, except for section 123 and 124 of the Indian Evidence Act, all the other documents you can procure under the provisions of section 91 of the Code of Criminal Procedure. Now, my friends, the reason I am telling you this is because you have to understand one thing. When you have a map, when you have a picture, when you have a chronology of incident, of how the incident took place and how the investigation took place, you have the chronology of both the things. In that case, you have to take instructions for your clients. For example, I'm just giving you an example. Now, there is a document in your charge sheet wherein there is a Punchnama under section 27 of the Indian Evidence Act. And this Punchnama says that on this particular day, between 11:30 to 11:40 or 11:50, the accused made a statement before the investigating officer and two panchas that he is ready and willing to produce the weapon which he has used in that particular offense. This is a statement which is recorded at police station. The signatures are taken. Thereafter, at 11:55, we left towards the spot of incident, and we reached the spot of incident at 12:30. The accused went there, removed a particular weapon. We seized that, prepared a Punchnama, and came back to the police station, and we reached the police station back at 1:30. This is what is written in the Punchnama. So, my friends, you are getting timings of different acts performed by the investigating officer in that Punchnama. 11:30, 11:50, 12:10 when he reached, when he came back to the police station, say 1:30, 1:20, whatever the timings are. And you have them at the back of your mind. Now, here is the exercise which comes to your help. When you ask your accused whether really the investigating, whether really you had made the statement, whether really you had gone to the spot of incident at this particular time, which is mentioned in the Punchnama, and if you get an answer from the accused, if you are able to elicit the truth from the accused, he will tell you, no, I had never made such a statement. Or if I had made a statement, but not at this time, not in this way, we had never gone to the spot of incident. Most of the times, the police officer, they request the relatives of the witness, okay, fine, just you give us a scythe or a bamboo or something by which it was assaulted, and they just seize it under the garb of section 27 of the Indian Evidence Act. So, you know the truth that they had not gone there. No such Punchnama was actually prepared. But on record, there is a Punchnama under section 27 of the Indian Evidence Act, which will show that yes, they had gone there. And the witnesses who are normally these days, they take government servants, public servants as witnesses. They are going to come and support this case. Then section 91 might come to your rescue. What all the documents you can make an application to the court and summon the investigating officer to produce documents. Now, the first and important document, which is a very important document in concern to investigation, is the station diary. The most important document. In station diary, there is an entry of each and every smallest and the minutest of the things which is made there. At this particular time, a particular officer has come to the police station and taken charge of the station diary, time, the officer, signature. There are columns in that particular station diary. Likewise, you will find so many documents, not only the case diary, not only the station diary, but my friends, there is a lockup register. Not only a lockup register, there are so many other, there is a logbook register, there is a logbook that shows you the movements of a vehicle by which the police had traveled from one point to another point. So if you call for these documents, if you are very sure about the truth, if you know that my client had never made a statement under Section 27 of the Indian Evidence Act, then you can always call for that station diary. You can always call for the lockup register. And if you can show it from the lockup register that when the prosecution claims that I made a statement under Section 27 of the Indian Evidence Act at 11:30, in fact, I was in the lockup and I did not come out. So from that, you can always point out that whatever claim is made by the prosecution is false. Similarly, a station diary. In the station diary, there is always an entry to the effect that at this particular time, we left with the accused by this particular vehicle to go to this particular place. And when they come back to the police station, then there is again an entry in that station diary that we returned with the accused at this particular time with this particular muddemal. Now, if we do not find any such entries in the station diary, if you do not find any entry in the lockup register that the accused was taken out from the lockup, then you can show to the court that the said Panchanama under Section 27 is false. Similar is the case with the logbook. Now, there are different registers. What is a logbook? Logbook is a movement of a particular government vehicle which shows that this particular vehicle with these many inmates or this particular police officer left from one point at this point of time to other point of other place and came back at this particular time. So the movement of that particular investigating officer can be traced by means of the log of that particular vehicle, because every investigating officer travels by his own official vehicle of which there is a logbook. So my friends, by exercising, but you have to be very, very careful. That's the reason I said, first you have to know the truth, or otherwise it's a double-edged weapon. It can boomerang against you if the investigating officer, as claimed in the Panchanama, has actually gone to the spot at that particular time. You will find the entries accordingly in those registers. And therefore, it is very important for us to know what is the truth. And once you know that the prosecution is lying on a particular aspect, then you have got this weapon under Section 91. You can call for this register. Now, what else? What else are what other documents are there? Now, there is one more documents, and that's the document of Muddemal register. Now, my friends, in a criminal trial, I don't know, we don't get this unless we actually experience during the course of trial. What happens now, this is a very interesting aspect which you have to understand. An investigating officer goes to a particular place, seizes certain articles, bloodstained clothes, just blood stains on that paper, or a particular weapon, or a vehicle, or any particular which we call muddemal, or a particular article. Now, after that article is seized, there is a Panchanama. Normally, this Panchanama is made under Section 165 of the Code of Criminal Procedure. Now, after seizure of this particular Panchanama, this particular article is brought back to the police station and it is kept or given or handed over to a Muddemal clerk. Now, my friends, this is very important. You need to find the chronology. This is what the chronology I am talking about. When the investigate, so the first time you will find that in the Panchanama at this particular date, this particular time, this particular place, a particular article was seized. This you will find in the Panchanama. Then it comes to the police station. The first entry is made in the station diary that the investigating officer has returned with this particular article. The third entry is found in the Muddemal register. A Muddemal clerk is there. That Muddemal clerk, the investigating officer is supposed to hand it over all these articles to the Muddemal clerk, who in turn gives a receipt to the officer, which you will always find annexed to the charge sheet. And then there is an entry made in that particular register that the Muddemal has been received, and this is the description of the Muddemal, and it is kept in safe custody. So from the spot of incident to the police station to the Muddemal clerk in that Muddemal room. From there, you have to understand this. From there, it goes to the forensic expert. So now you will find a statement of a police constable who is called as a carrier constable. This carrier constable, his responsibility is to take the custody of these articles and hand it over to a particular chemical analyzer or a forensic lab, which is normally in Bombay, Pune, nowadays in Kolhapur also for our place. So then you see the chronology of all these articles. The article has been seized at one particular place. It comes to the police station. It is handed over to the Muddemal clerk. Then the carrier takes the custody of it and then goes to Bombay or to whatever place of lab and hands it over to a particular forensic expert. The expert carries out whatever test he's supposed to carry out. And then with his report, he sends back all these articles to the police station, who in turn returns all these things back to the court. So my friends, do you understand the importance of chronology? That one particular article has been moved and handled by many different people at different times, on different occasions. And therefore, the law is very clear about it. The prosecution has to always establish the chain of the point from where they seize the article till the point when it reached the court. Now, I can give you an example as to how you find discrepancies in these particular things. Now, what happens is when this Muddemal is given to a particular Muddemal clerk, in my experience, the police never follow any rule in the book. The investigation is carried out in haphazard manner, and therefore you will never find an entry of a particular Muddemal being handed over immediately after it has been seized, because it never happens actually. So many a times you will find that there is no entry, or if at all there is an entry, it's not at the time and as mentioned in the Panchanama. This is one thing. The second important thing is you always see the statements of the carrier police officers. They will say that I have taken the custody of this particular article and I have handed it over on the next day or 2 days thereafter to the expert. So the question is, from the point when it was seized till the point when it reached the expert, in what condition these articles were lying is the very, very important aspect you need to bring in order to substantiate your defense. Because, for example, if there are blood stains, if there is a blood stain shirt of a deceased or the complainant, what the prosecution does is that they will seize that particular shirt, send it to the police station, to the Muddemal clerk. After a few days, they will take the blood sample of the complainant, or if it's a deceased during the course of autopsy, they collect the blood and then send both these articles to the expert. The shirt is seized at a particular point of time. The blood is taken by the medical officer at a different point of time, and thereafter it is sent to the expert. So there are always chances that, my friends, there are always chances that the blood which is collected during the course of investigating from the medical officer can be misused on that particular clothes, or even of that of the accused. Even the blood of the accused, which is taken from the medical officer, can be misused by the investigating officer. And therefore, this chronology, the chain of all these articles is very, very, very important. And you will have to understand the importance of all these registers. Now, there is one more register which we normally don't look into. But when there is a case which includes a great magnitude of investigation, I had an opportunity to handle a case wherein 128 witnesses were examined, where murder of 10 people was committed at 3 different junctures by accused. Now, with this kind of magnitude of the offense and the investigation, it is very important to understand that different officers are deputed for doing different things. Like one officer cannot do the whole investigation, and therefore, we have to understand this thing, that different officers are subordinate officers are deputed to do different particular things. And what you have to understand, there is a register called as duty batwada register. That is a duty assignment register, you can say. They call it a duty batwada register. There is always this register wherein a particular police constable is allotted a particular duty. Like if I am a constable and I am appointed as a Muddemal clerk, on that particular day, you will find in that register, there is always a note that these are 3 are sentry guards, these 2 are the Muddemal clerk, he is a station house officer, he's in charge of the station diary, he's a station house officer, this particular point is sent for, this particular constable is sent for patrolling, this particular constable has gone for investigation, the investigating officer is is busy in some different, all these things are noted in that duty batwada register or the duty assignment register. And my friends, in these kinds of cases where there is a lot of investigation and so many police personnel are used during the course of investigation, you will find a lot of flaws, loopholes in the case of prosecution by getting to know all or getting the copies of these register. And how do you get this? I have already explained to you. You have to make an application under section 91 of the Code of Criminal Procedure. But again, I am telling you, this is a note of caution. You have to understand this, that unless and until you're sure about a particular thing, you don't call for all these documents. This will be in aid, just in case you know the truth, you're sure about the truth. And therefore I said, my friends, what is important is to know the truth and the unravished, unblemished truth. That is what you have to know. If you know the truth, if you know this has not happened, then all these documents, all these registers will come to your help. Now, my friends, I was with all these kinds of documents which we are considering under section 91. What we normally don't do is minutely read the documents along with the charge sheet. For example, I was explaining to you that a Panchanama under section 27 is prepared, or for that matter, any Panchanama is prepared. You must have come across, if you are practicing nowadays, that nowadays the police always require government servants as Pancha witness. They requisition the government servants as the Pancha witnesses. And therefore, you have to understand a very important thing. Now, first, that a government servant, he is always bound to tell or depose in favor of the government because he's a government servant. So what you have to understand, my friends, is that you also have to be now prepared. Now, the prosecution, what it's doing is purposely calling the government servants, the public servants as witnesses so that they don't support the prosecution case or in other the case of accused, or in other words, they will definitely support the case of the prosecution. They will not tell the truth. Even if the investigating officer has done something wrong, they will still support what is written in the Panchanama, and therefore nowadays the police officer in serious offences, they requisition the government officers or the public servants as the punch witnesses. Now, my friends, how do we deal? This is again a challenge. The prosecution, the investigating agencies is coming with different techniques to support their own or to suit their own causes. Then what do you do about it? Now, what is important, if you have realized, I don't know whether you have realized this fact, but in the charge sheet nowadays, you will always get letters. The letters sent by the investigating officer to a particular head of department of a particular government office. And in that letter, he requisitions that, or he requests that particular government officer in charge of that particular office that I want 2 persons, government servants from your office to remain present at this particular time for a Panchanama. This is what is written in the letter. Now, my friends, please kindly, we normally don't even look at these letters. But if you start scanning these communications minutely, this is how we counter the prosecution. These are the tools which we have in our hand. They give it to us free and we don't even consider it. Now what happens is that the officer who receives this particular letter, there is always a receipt. He puts an acknowledgement that I have received this particular letter at this particular time. Sometimes it's there, sometimes it's not there. And in that particular letter, the investigating officer always writes that I want this particular punch witness to remain present at this particular time, at this particular place. Now, just now I am having a case. I mean, I could have shown it, but I don't think it's possible on this. If practically, I would have actually shown you what happens. Now, here in a case in hand, where an offense under section 353 has taken place, and they have requisition, there is a letter, and the letter says की आपल्या कार्यालयातील 2 व्यक्तींना पंच म्हणून दिनांक सो अँड सो रोजी 11 वाजता या ठिकाणी हजर राहण्यासंदर्भात कळवावे. This is what is written in that particular letter. So what it says is, you see to it, or I am requesting you to send 2 persons from your office to remain present at this particular place at 11 o'clock for a Panchanama. Now, my friends, the actual Panchanama was prepared, or actually Panchanama was done at 3:30 p.m. Now, kindly see, it's a very simple thing. In the letter, it's written that you have to remain present at a site of incident or the place of Panchanama at 11 o'clock in the morning, 11:30 in the morning. The Panchanama starts at 3:30 p.m. in the morning on that particular day. Now, the question is, if the communication was true and the Panchanama was true, definitely there would have been another communication saying that no, the timing has changed and you have to remain present at 3:30. Now, nothing of that sort is normally happening. The police go and pick up the officers from their places, from their offices, in their vehicle, take them to the spot of incident, write down whatever they have to write down, then just ask them to sign. They also just, without even looking at it, just sign it. And then when they come to the court, before entering in the witness box, they just refresh their memories, what is written in the Panchanama, and then they just, depose on the basis of that. So what is important is, if you use all these letters, you will find so many contradictions. And on top of that, if you prepare your case well in advance, and if you know the truth, you might as well make an application under the Right to Information Act to that particular office, asking him particular and definite questions as to where this gentleman who is supposed to be a punch witness at this particular time, at what point of time he left the office, whether he had been to his office, at what point of time he left, and what point of time he came back. Whether you have received any letter and if you have received a letter from the police officer, at what point of time. Normally in the trap cases, you will get amazing results from this information which you get under the right to information. Now, my friends, you don't get all these things in CRPC and Evidence Act and any other documents. This you will get by experience. And therefore, I'm just trying to share my experience with you that here is one more tool to deal with all such situations where under the Right to Information Act, nowadays, if you are smart enough or you think yourself to be smart to getting the government officers as punch witnesses, then we are dealing with this issue by getting under the Right to Information Act, where this punch witness was, what he was doing, at what point of time you received a letter, at what point of time he reached the spot of offense, or any other thing. So, my friends, as it keeps on changing, as the investigation, the modes and modalities of investigation keeps on changing, you will have to develop yourself. You have to come with different techniques. And therefore, I always keep on saying that you will have to share your experiences. Unless you share your experiences, you will not come to know about these different aspects. Now, there's one more important aspect which you have to understand, my friends, that when we read a document, now let us take one Panchanama. I have with me a Panchanama under section 1. It's a simple Panchanama under section 165 of the Code of Criminal Procedure. Now, nowadays there are formats. For every Panchanama, there are different formats. If the Panchanama under section 27, then there is a format. If it's under section 165, there is a format. For every particular Panchanama, they have given format. Now, this is a Panchanama under section 165. Now, read every column of the Panchanama, and you will find a lot of different aspects which you normally don't see in that Panchanama. Now, it starts with totally there are columns, 16 columns. There are totally 16 columns in the Panchanama, right? Now, if we read the evidence, if we read the CRPC, section 165, the format, you will find in the heading search, oblique production, oblique recovery under section 165 of CRPC. Now, my friends, we don't go into this detail, but I feel we should. Now, let us read what section 165 of the Code of Criminal Procedure says. Now, section 165 says, whenever an officer in charge of a police station or a police officer making an investigation has a reasonable ground for believing that anything necessary for the purpose of an investigation into any offense which is authorized to investigate may be found in a place within the limits of the police station of which he is in charge or to which he is attached, and that the police and that such thing cannot, in his opinion, be otherwise obtained without undue delay, such officer may, after recording, now kindly see the words, after recording in writing the grounds of his belief and specifying in such writing, so far as possible, the thing for which the search is to be made, search or cause search to be made for such thing in any place within the limits of the police station. Now, what is the first prerequisite? The first prerequisite is that he has to make a note of it, specify in writing, he has to note it down, and that is normally done in the station diary. The belief that why he has to go to that particular place, what article, as far as possible, what article he is going to recover or seize that particular place. Now, do you come across any such note you found, any such copy or extract of a station diary? You will just find a simple Panchanama under section 165, which is a printed format, which is normally written by a writer constable, not even the investigating officer. Now, the next two important aspects are very important. Then you directly go to subsection 3. Subsection 4. The provisions of this code as to search and warrants and the general provision as to the search contained under section 100 shall, so far as may be applied to the search made under this section. Number 5. Copies of any record made under subsection 1 or subsection 3 shall forthwith be sent to the nearest magistrate empowered to take cognizance of the offence, and the owner or the occupier of the place searched shall on an application be furnished free of cost with a copy of the same to the magistrate. Now, do you find that any such Panchanama is immediately sent to the magistrate? Just see the charges which you might be dealing with right now. You will never find that a copy of any Panchanama under section 165 of the Code of Criminal Procedure Code is ever sent to a magistrate. Further, now what it says is, as far as possible, not even as far as possible, the words are, the provisions under section 100 shall apply to all the searches under section 165 of the Code of Criminal Procedure Code. And therefore, my friends, I am just inviting your attention to section 100 of the Code of Criminal Procedure, and then you will understand what I'm trying to point out. If we come to section 100 of the Code of Criminal Procedure, it is regarding person in charge of a closed place to allow such search. Wherever any place liable to search or inspection under this chapter is closed, any person residing in or being in charge of such place shall, on demand of the officer or the other person executing the warrant and on production of the warrant, allow him free ingress thereto and afford all reasonable facilities for a search therein. Now I'll directly come to the important aspect of this search. The search shall be made in presence. Subsection 4. Before making the search under this chapter, the officer or the other person about to make it shall call upon two or more independent and respectable inhabitants of the locality in which place to be searched is situated, or if any other locality, if no inhabitant of the said locality is available or is willing to be a witness to search, to attend the witness, the search, and may issue an order in writing to them or any of them so to do. So what is supposed to do? Now we have just forgotten the provisions of section 165, section 100. He is supposed to call the inhabitants of that particular locality from where a search is supposed to be made. And then you look at the investigating officer who calls for the panchas, who are the government officers and who come or who hail from a totally different place. Now, there is no explanation given why he is calling for that particular panchas from a different place or the government officer, because he has to record that the panchas were not available in that particular locality. He has to make a record of that particular thing. And as a reason of such, I am calling these witnesses as panchas from a different place. Now, kindly see also subsection 5 and 6. The search shall be made in their presence, and a list of all these things seized in the course of search and the places in which they are respectively found shall be prepared by officer and other person and signed by such witness, but no person witnessing search under this section shall be required to attend the court as a witness. Further, the occupant of the place search or some person in behalf shall in every instance be permitted to attend during the search, and a copy of the list prepared under this section signed by the said witness shall be delivered to the occupant of that person, occupant or the person. Now, my friends, you have to understand this. Whether it's a Panchanama under section 27 or section 165, whatever it is. Now, normally it so happens that the investigating officer goes to the house of the accused and a search is made. And during the course of that search, so many articles are seized. Now, what we have to understand is the purport of section 100 is very clear that from the place where you have seized this particular articles, if it's a house of the accused or within the control of the accused, then the investigating officer has to prepare a list of all the articles seized. He has to hand it over to the person who is in charge of or who is in possession of that particular house or whatever it is, and he has to have an acknowledgement of the same. So section 165 and section 100, if we read section 165 with section 100 of the Code of Criminal Procedure, they are supposed to have firstly the local witnesses. If not, they have to record the reasons for the same. Number two, if they are seizing particular articles from a particular place, they have to make a list of it and give a copy of that list to that person who is in charge of that particular house or any enclosed place. Now, my friends, you will never find such thing in the investigation, because most of the times the investigating officer doesn't bother to go to a particular place and do a particular thing. He just deputes somebody or gets a particular article, and then a formal Panchanama is prepared. And therefore, my friends, you need to know the truth. The reason I keep on reminding this fact to you, when you know the truth that this is not happened, then there are so many other provisions in the Code of Criminal Procedure. There are so many other documents by which you can show that whatever investigation carried out by the investigating officer is absolutely false. Now, after having seen the provisions of section 100 and section 165 of the Code of Criminal Procedure Code, we have to come to the most important document in any criminal investigation, and that is the FIR. My friends, even I was doing the same mistake for quite a long time before I realized a few things. That few years back, let's say 6 or 7 years or 8 years back, we used to get a handwritten complaint, and on the left side of that complaint, on the left side of that page, there used to be a crime number, then there used to be a time as to what time the information was received at police station. Then there used to be a time at what point of time the FIR was registered, and the sections and the name of the police officer who has noted down this or registered this FIR. This is what we used to get few years back. But with the technology playing its role, and with all the police stations and the different police departments being connected to each other, nowadays an FIR is recorded electronically on a laptop or a computer, and the timings noted in these FIR are very important. Now we read a FIR and we fully concentrate on the contents of the FIR as to the incident. What is the version of the complainant? We concentrate fully on that part. But what we are missing, my friends, are the different columns which are mentioned in that particular FIR. And if we see those columns, this is a very interesting thing. You will realize that you will not imagine the kind of lacunas, loopholes you will find in an FIR which is presently given. And I'll just demonstrate it to you by reading, because I can't show it to you right now. Otherwise, it would have been very easy for everybody. Now, my friends, in this FIR in the section 154, it's a printed format. There are 15 columns. Column number 1 to 15, and every column has sub-columns. Now, normally we don't look into these columns. Two important aspects normally what we are trying to show. Either we are trying to show that it's anti-timed, or we are trying to show that there is a delay in FIR. My friends, you will realize one thing, that in the FIR, normally in the body of FIR, it's never written why there is a delay in lodging an FIR. The witness comes in the witness box and he starts deposing. that on this particular day, this incident happened, so and so and so and thing happened. These are the chronology of incident. And thereafter, I was in a state of shock. I couldn't decide what to do. Therefore, in that state of mind, I did not go to the police station. But after some point of time, I took somebody's opinion. I gathered courage, and thereafter I reached the police station, and thereafter I gave a complaint. Or sometimes the prosecutor is very smart. He does not bring all these things in chief examination. But when you try to explore or exploit this issue, that you have not given this FIR in time and there is a delay, he suddenly comes with an explanation that no, this is the thing happened and that is the reason I could not give the FIR well within time, and therefore there is a delay of 1 day, 2 days, 6 hours, 7 hours, 8 hours, depending upon the circumstances. In these cases, my friends, there is a column number 8 of the FIR is a printed format. And you have to understand this. Column number 8 of the FIR says, reasons for delay in reporting by the complainant informant. Now, this is a column. It's written in a very small, minutely written thing. You have to read it very minutely. A very small font it is. Now, column number 8 of the FIR very clearly states that while recording an FIR, if there is a delay, the duty is cast upon the person who is noting down the FIR, who is writing down the FIR, who is registering the FIR, to ask to the complainant why there is a delay in registering an FIR. Because at the foot of that particular FIR, you will find signature, thumb impression of the complainant, and signature of officer in charge of the police station and the person recording the FIR. So this particular printed format, it's not just uploaded on the computer or the laptop to their system, but they have to take a printout of it, and a signature is obtained on that complaint, that 154 form itself. So therefore, whenever a witness comes to a witness box, when there is no explanation in the body of the, you never find any explanation in this column number 8. But he starts giving an explanation in the chief examination. Or if you are cross-examining a witness and all of a sudden he comes out with explanation, then you will have to ask that particular witness whether you had stated this fact to the police while recording the FIR. And he will give you a standard answer. No, I did not state this fact because I was in some sort of a shock. I did not realize to give this particular incident or give the explanation for the delay. Then you ask the second question to the witness, did the investigating officer or the person recording this complaint ask you why there was a delay in lodging the complaint? He will definitely say no, he did not ask me. Then you just leave it at that. And when the person who has recorded the FIR comes to the witness box, my friends, you will have to take a detailed cross-examination. You will have to ask him firstly whether you inquired with the complainant why there was a delay. If he says yes, the column number 8 is there, which is always blank. Nothing is noted therein. If he says no, then you show him column number 8 of the FIR and ask him, it is specifically mentioned that you are supposed to inquire with the complainant, is there any special reason why you did not do it? And you will get your answer. And the point of delay which you are trying to explore, you will get a substantial evidence on that particular point. And therefore, my friends, we have to meet these new challenges with new technologies coming. If they are coming with a printed FIR, if they are coming with a central system where they upload the FIR immediately, you will also have to go into detail in every document, in every system that they develop. You will have to develop a counter system for everything. Now, my friends, in the FIR itself, there is one more important aspect. Normally, what we always see the timings. What time the incident took place, what time he reached the police station, when the FIR was registered. So we always try to find out these timings. And these timings are very important to show the truthfulness or of the prosecution, investigating agency as well as the complainant. If we see the printed FIR, the column number 1 of that FIR, I had requested the coordinators to tell you that you should be keeping the charge sheet and the documents with your hand. If you have it, you might find it. The first column of that particular FIR, column number 1 is district, police station and year. Now this column number 2, or sorry, the second part of this column number 1 is very important. It says FIR number, date and time of FIR. And there the date and time is specifically written. Now I'm having, just for an example, I'm just having a FIR in my hand and it says FIR number 369, date and time 12/12/2018 at 4:16 AM. 4:16 AM. पहाटे 4:16 रजिस्टर झालेली FIR आता या क्षणी माझ्या हातात आहे. And the time is 12/12/2018. Now the next column is the column of sections wherein the detailed sections are mentioned. Now column number 3 is very important, my friends. Occurrence of the offense. Date 11/12/2018. From 2. These are the two columns. Date from 11/12/2018. Date to 11/12/2018. So there is a second column, that's the time. So the incident has taken place between 11:15, the morning of 11/12/2015 at 11:15 AM to just 15 minutes thereafter, 11:30 of the same date. So 11/12/2018, the incident has taken place in the morning at 11:15 AM of that particular day. Now kindly see column B of column 3. There are sub-columns. Column 3 has 3 sub-columns, A, B, and C. Information received at police station. Now this column is important. It says 11/12/2018 at 22:53 PM. So the incident has taken place in the morning at 11:15 AM. The information is received by the police station at 12:53 PM. रात्रीचे 10:53 ही माहिती पोलीस स्टेशनला आली आहे. सकाळी 11:15 घटना घडली आहे. Then column number C of column 3, general diary reference number 36, date and time 22:53. It's the same time. Now what you will understand by this is that there is a time of registration of a FIR which is at 4:16 of the next day. पहाटे 4:16 12 तारखेला ही FIR upload झाली आहे, register झालेली आहे. Kindly see, this is very important. Now this incident has taken place on earlier day in the morning at 11:15 AM. The information was received on that particular day at 22:53, that is 10:53, and column number 5 of that particular FIR says place of occurrence, direction and distance from police station, and the distance is 45 kilometers. Now my friends, I'm just giving this as an example to you. Now my friends, you have to understand this. The incident has taken place at a distance of 45 kilometers from the place of incident. The incident has taken place in the morning at 11:15 AM, and the information has received. The information was received by the police station in the night of 22:53. What does it show? There is almost a delay of whatever 20 hours or whatever hours it is. Throughout the day, this 12 hours, the FIR, the information was not received by the, this is an offense under section 353. The question is that the information was received late, number one, and it was uploaded to the system at 4:25 in the morning of the next day. Kindly see to what extent the delay is going. Now, this is what you find from the FIR. Now, that's the reason I was telling you at the beginning that you will have to understand the chronology of incident, because in this particular case, I am having a medical certificate of that particular witness. He was a government officer and he was not allowed to do his duty and he was assaulted. And there's a medical certificate in this particular case which says that he was admitted to the hospital on the same day, that is on 11 at 12:30 p.m. दुपारी 12:30 वाजता हॉस्पिटलला he was admitted, and the distance between the hospital and the police station is hardly 10 minutes. Now, my friends, this gentleman will definitely come with explanations that I was not in a good state of mind. I was assaulted. I was in a state of shock. You will get a lot of information from these columns in the FIR. So you will have to make a chronology. The incident has taken place at 11:15 in the morning. He has reached the hospital at 12:30. The hospital is at a distance of 5 minutes from the police station, but the police have received the information at 22:53 in the night, and it was finally uploaded in the morning at 4:25 p.m. You have just got a lot of material for cross-examination from one document itself, from the FIR. And this is precisely the exercise which a lawyer needs to do if he wants to succeed in his case. And this is what I was trying to tell you. You have to know the truth. You have to read the documents minutely. Every single document you have to read minutely, and you will get lots and lots of material from it. And the reason for this is very important. You have to understand, as I was telling you, you have to use your common sense. What happens in the investigation is this, that incident takes place between two persons. They come to the police station. They give their complaint to the police station. He's a third person. He does not know anything about it. As per his intellect, as per his intellectual level, he understands what that person is trying to say. He adds so many things as per his intellectual level into that story, and then he creates an FIR. So it is not only that complainant who is trying, that poor complainant who comes with whatever his case is, it is that person who is recording the FIR, he comes into the picture, he adds his knowledge to it of whatever experience he has, and then the FIR is created. After the FIR is created or is written down, then comes the investigating officer with whatever intellectual level he has and the knowledge he has. He does his investigation and he adds so many things. So by the time a charge sheet is prepared, the actual incident is diluted into so many different things by intervention of so many different people. Because I'll tell you what, they will go to an expert and they will ask a question to him. Okay, this injury, what is the time this injury might have happened? What is the time of the death? If the medical officer tells them that this must be the time of death, they will manipulate the timings in the investigation accordingly. So there are 100 people interfering into the investigation, and they dilute the real story from whatever it has happened to the charge sheet. And my friends, you are supposed to take the benefit of this fact only. This is what you are going to get. The material for cross-examination, the material for preparing your case and your defense, you will get out of it. Just before I would go to the next point, I would like to ask the coordinator, how much time do I have?
Yes, sir. You can carry on, sir, for next half an hour.
Half an hour. Okay, sir. Yeah, fine. So, my friends, this is how you get to the bottom of the case and try and create a defense. Now, after having done all this exercise with the investigation, with the charge sheet, with the documents, with the statements, with the information from the accused, Now you are prepared for conducting a case. And therefore, this is what I feel. If you are good on your seat, you are the best on your feet. This exercise you have to do in your office. So therefore, if you are good in your seat in getting all this information, collecting the truth and getting the facts straight, everything in your head, then I don't think you will have any problem at all when you are conducting the cross-examination or the arguments. So after having done all this exercise, whatever I told you, collecting the document section 91, finding out the the policies in the evidence and everything, then you fix up a strategy. This is the most important challenge for a lawyer. What is the defense? Nowadays, because I remember the old days, good old days, I should say, defense of total denial. This was the best defense in those days. But now, with the acts like prevention of sexual assaults or offenses against the children, the POXO Act, or there are so many acts, I should say, the Prevention of Corruption Act, the burden is now shifting on the accused to prove certain things. So therefore, my friends, it is not just easy to say, no, I have not done this. I don't know who has done it. Now the burden is slowly coming upon you. It's shifting on you. Earlier, it used to be the onus, but now the burden also is shifting on us, that is the defense lawyers. And therefore, you have to come up with a particular defense. And not one defense, there has to be multiple defenses ready. And this I call is strategizing for a defense. You have to fix up a strategy for defending a accused. And it is very important, and it has to be done at the beginning. You can't just do it at the end of the trial. We'll say what evidence comes and then I will decide. Yes, you have to be flexible, but that doesn't mean that you don't have anything in your head. And this, according to me, is the most important challenge which a lawyer facing a lawyer practicing in a lower court, in a sessions court, in a magistrate court, or defending an accused faces. So therefore, my my this view of looking at it is, I had mentioned in one of my lecture, SWOT. Remember these four letters, SWOT: strength, weaknesses, opportunities, threats. By this I mean you have to know your strength. By this I mean you have to know your weaknesses. And by this I mean you have to know the strength of the prosecution and you have to know the weaknesses of the prosecution. And by opportunities and threats, I mean the opportunities which you can capture and those which the prosecution has if you open up yourself, and the threats likely by putting certain questions. So the strength, weaknesses, opportunities, and threats, you will have to jot it down, my friends. And therefore, what normally you do is, or this is my way of doing it. Different people have different ways of doing it. Divide it in two parts: circumstantial evidence and the direct evidence. So eyewitnesses are the direct evidence. Any other witnesses pointing out to any other circumstance, or the reports of the chemical analyzers, or any forensic reports, or the investigating officer, all these, or the Punchnamas, the Article Cs, all these are circumstantial evidence. So normally you divide them in two parts: direct evidence and circumstantial evidence. You have to deal with direct evidence in a different manner, and you have to deal with the circumstantial evidence and witnesses on circumstantial evidence in different manner. And therefore, my friends, you have to formulate a strategy. And what is that strategy? Is that at the end of all this exercise, you have to come to a conclusion that there are 10 witnesses, out of which 2 are direct witnesses, right? The rest of the 8 witnesses are on circumstantial point, and these are on the direct point. And therefore, I want 1, 2, 3, 4 things from the direct evidence or witnesses on the direct evidence. And I do not want, or if they come on record, I have to somehow see to it that these circumstances, in some doubt is created, or you can wash out those parts. Similarly, in case of witnesses on circumstantial evidence, I want these circumstances to come on record. And if these circumstances are brought on record by the prosecution, somehow I have to show that these circumstances are not believable or not probable. So you have to be prepared before going for a trial, what you want from a witness and what you don't want from a witness. This is called as a strategy. When you are ready with this, then you are ready for a trial. And therefore, my friends, you have to be very, very vigilant and focused on what you want from a particular witness and what you don't want from a particular witness. Then the next important challenge is the cross-examination. You must have heard a lot of senior lawyers discussing about cross-examination. I will not discuss much about cross-examination, but there are a few points. Now, since my stepping in this field of practicing as a criminal lawyer, I have been listening to so many things. You shouldn't be asking this question. You should know what to ask. You should do this. You should that. You do that. You don't ask this question. This is a rule. This is another rule. You don't ask which might incriminate you. Yes, all these rules are there. But my friends, I have a totally different rule. And that rule is that there is no rule. This is my rule for conducting a criminal trial. Because human tendencies change as per a human being. Different brains have different imagination and different level of understanding. So you cannot formulate exact rules. There can be certain guidelines, but there cannot be any rules for cross-examination. So you have to be flexible. Therefore, while conducting cross-examination, only 3 or 4 things, my friends, I would like to suggest. The first thing which I have realized is that taking somebody by surprise. I just saw Advocate Sudeep Pasbola sir on screen, and he's in one amazing person. His lecture I have heard in criminal trials. So while cross-examination, the most important aspect, my friends, we have to concentrate that you take a witness by surprise. When a witness comes in a witness box, in chief examination, he's tutored. He's told what to say, exactly what to say. He's tutored what you will be asked, what he will be asked in cross-examination. And therefore, if you start a cross-examination in a particular way regarding what he has stated in his chief examination, he will be immediately ready with that answer. So my friends, you have to see that you have to take a witness by surprise. And therefore, this digging up of the history of a witness is important. Maybe it is not relevant to that case at all, but you have to bring that particular witness on a totally different track so that he loses the line of what he has stated in the chief examination. You can ask any question you feel so. His marriage anniversary, I don't know. The judge might say whether this is relevant, but then all of a sudden you posing a totally different question that distracts the particular witness. The second important thing which happens is that a witness gets alert. He always feels that you are an adversary, and when you are asking some irrelevant question according to the legal fraternity, but he in his mind knows that he is a lawyer, he's a learned person, he must be having some plan. He's going to grill me to something. He's going to take out something from me, and then he gets more alert and he starts thinking on that question, particular question, and then he loses the sight of what he has stated in the cross-examination. So take the witness by surprise, ask a question in a totally different context, and you will get amazing results out of these questions. Then one more important aspect which I have understood over a period of time, falsus in uno, falsus in omnibus. Now this is a Latin proverb or a saying which we have heard for so many times. You must have heard this in so many judgments. Falsus in uno, falsus in omnibus. Just excuse me. By this maxim is not at all applicable in India. But I have a different perspective to look at this particular maxim. The Honorable Supreme Court has time and again reiterated this fact that falsus in umno, falsus in omnibus is not applicable in India because the courts are saddled with a responsibility to separate the chaff from the grains or the grains from the chaff, whatever it is. I take it in a different way. For me, the simple meaning of this maxim not being applicable to India is that we lie to a considerable extent. The witnesses lie to a considerable extent. And this is, my friends, what you have to exploit. This is what you have to find out. And according to me, you have to not just, exploit it in a way by bringing it in on record, just bringing the fact on record that he's a liar. No. You can use this particular thing that a witness is lying in a totally different way. And this is how I have tried to use it. Just let the witness know that you know that he has been lying on a particular aspect. Don't expose that lie. Just let the witness know. While cross-examining a witness, you just say a few things that you know a particular thing that he has done. Just a comment which you pass. Make the witness alert of the fact that you are fully aware of a fact that he is lying on a particular fact and you have got the evidence to show that he is lying. Just don't exploit it, just don't expose it. This fear in the mind of that particular witness that the adversary is knowing that he has lied on a particular aspect will yield so many admissions to you. But you exploit it, you just expose him to that lie, and once he is exposed, once he is out, then he will retaliate and he will not favor you or not give you any admissions. So as far as possible, keep this part of exposing a lie of a witness at the end of your cross-examination. But at the start of your cross-examination, let him know that you know that he's lying and you are having evidence. That will bring that witness under a lot of pressure. My friends, these are just a few things which I have been using in my cross-examination. That brings us to the last part of this session, which I feel we should understand. Arguments. Now, before arguments, one thing which I missed is that one more challenge which we lawyers face nowadays is this different kinds of experts which are coming, who are coming in the witness box to support the case of prosecution, like a DNA expert, expert if the dead body is not identifiable, there is something called as superimposition. He gives you a version by superimposing a photograph on the skull of that particular dead body. You superimpose it and they say that this might be a dead body of this particular person. Then there are different witnesses like electronic evidence, CCTV footage is brought on record, handwriting expert, medical evidence. There are so many experts. And now when these witnesses come or these reports come, we get scared. Oh my God, we have a DNA report which is supporting the case of prosecution. We have a handwriting expert and we get scared because we feel that we don't know anything. And my friends, one thing you have to understand, you have to be jack of all trades and master of one. This is the principle which I have been following. You have to know something about everything. There cannot be any field of which you don't know. And that's the reason I think we are called learned lawyers. We have to know something about everything. And how do you go about it? How do you know about these fields? There are two ways. Don't get scared by any report. I have cross-examined a DNA expert I mean, there are very stalwarts which I am seeing on my screen who I know are hearing me, and I'm just nothing compared to them. But I'm blessed, I'm lucky to have had encountered cross-examining expert witnesses, whether it be medical, whether it be DNA, whether it be voice. In nowadays, in the prevention of corruption cases, there is always a audio recording. Now the question is, how do you deal with this? There are three ways of dealing with this. This is my way of looking at. Number one, look at it very logically, not as an expert. For example, I'll just give you an small example for an expert. There was there is a case under the Prevention of Corruption Act, and there is an expert who has given a report that the voice in recording A and the voice in recording B are similar, and they could be of one and the same person. And then they give the graphs by which they show and compare that this could be of the same person. Fine. Now I don't know anything about that particular. Uh, I don't have any expertise in that particular field. I think logically, how do I disprove all these things? I don't know anything about that particular field, and I'm just a common man. Still, I want to disprove this particular thing. Then I go logically. I go to the root of the matter and find out that when was the recording A done, in which device it was done, when it was copied to the laptop, from that laptop when the CD of that particular recording was prepared. Then I go to the next part, the specimen sample of the accused was taken. When was it? When was that specimen sample taken? In which uh, instrument that sample was taken? When what is copied to the laptop? When was a CD prepared? And when both these CDs came together and when they were sent to that expert. So the time when the first recording was done to the time when the recording was sent to the expert, in whose custody was it? Whether there is any chance of manipulation with that. This is a very common thing which you can find out from the record which has been produced by the police. You don't need any expert. If you are able to show that both the recordings were in the laptop of the investigating officer or that police officer, they could have definitely copied a few things from one recording and pasted in the copy in the other CD or other recording by which they are trying to implicate you. So therefore, this is a logical thinking. Then what you do is you have now you have access to everything. The internet has got you everything. Google gives you everything. Just go on the internet, find out different manner and mode in which the comparison of voice is done or sampling is done or how a DNA expert works. You just find out all the material data. You study yourself and then you formulate your questions. This is the second way of looking at it. First, a logical way. Then you have to be an expert. You have to take all the pains and find out the data, the details of how the comparison is done, how DNA samples are taken, what are the protocols of that, what are the SOPs, the standard operating procedures for that. You get all this detailed material, and then you again compare your logic with that material, and you will have questions. You will have so many questions on your own, and then is the last way. You have to meet an expert. You have to see an expert. Unless you have the logical reasoning, unless you have these pointed questions, you cannot go to an expert and say, okay, just give me a proper defense. He will not be able to do. No, you will have to take all the pain, you will have to do all the hard work, and then you prepare a questionnaire of yourself. These are the questions what I have, and this is what I want to do. And therefore, you go to the expert, and then you can seek his opinion, because finally you are the one who is going to cross-examine that expert. And therefore, in order for yourself to be prepared with the questions, you need to do all this exercise and be ready with the questionnaire. And therefore, my friends, don't get scared of any technology. If there is a technology, there is always a counter technology. If there are experts, then there are experts otherwise also to disprove that thing. If there are SOPs, then you will find that all the experts, every expert is missing out on that SOPs. They are not following the protocols, and therefore you will get ample material. Never get scared of all these reports, because this is one of the important challenge which my young lawyers and aspirants are facing nowadays. I come to the last part of this discussion, and that is the argument. Now, my friends, I think it's the best tool a defense lawyer has. It's an amazing thing. And the basic thing which you have to understand is communication. The word communication is the most important thing, because you are trying to communicate to another person. So one person is trying to communicate to another person his thoughts, his ideas, and his version of a particular thing. If you are a good communicator, then I think things are very easy. So you have a very good case. You have conducted an amazing cross examination and you have got so many law points. But if you are missing out on that communication skill, I think you might have to face real and lot of hardships, because you are not able to deliver it across to the judge who is finally going to decide this particular case. And therefore, I have kind of formulated my own way in how I argue before a judge. First of all, I don't believe in long and protracted arguments. No, I don't think any person is able to absorb one particular point beyond 25, maximum 15 to 20 minutes. So if you are arguing on a particular point on a section, you are arguing a Punchnama, how this is false. If you read the evidence of the punch witness, the investigating officer, and the expert and everything, you read out the depositions of that witness, the judge is going to lose the track of that particular thing. So what I feel you should do, it formulates small points. For example, if it's a case relating to circumstantial evidence, last seen theory, recovery of articles, motive, and absconding. Let's say he was absconding. These are the four circumstances which are against you. Take one part. First, motive. Who are the witnesses on the motive? One, two. These are the two witnesses on motive. I am just trying to suggest or prove that the motive is not proved. How? These are the two witnesses on the point of motive. For these reasons, they are not believable, or their evidence is not believable. Then come to the last scene. These are the two or three witnesses who have lastly seen the deceased and the accused together before he died. For these three reasons, these witnesses are not believable. So take one point and argue that point instead of reading one witness every time and showing that how he is not believable witness. The judge will be burdened by that argument, because he's already read the evidence when the prosecutor has argued this particular point. So my friends, when you are arguing any matter, see to it. This is an important challenge nowadays. Just keep on telling you, come to the point, come to the point. Don't give a chance to just to say come to the point. Don't give a chance to a judge to give a kind of expression where he says, what are you arguing? Don't give him a chance. You have to create a curiosity in the mind of the judge of the point which you are going to argue. So just directly don't open up a point. My lord, this is one interesting thing which I want to point out. You just open up with this sentence and see to it that it's really interesting. That creates a curiosity in the mind of the judge, and it immediately draws the attention of the judge towards you. So therefore, when you first say this sentence, then immediately the judge, you have drawn the attention of the judge towards you. Then you have to give him different aspects of what you have cross-examined. then you will have to make him understand that even though he was there and he has witnessed the cross-examination, but he did not understand the import of it, and therefore you are pulling something new out of your hat or from that evidence. So make it very interesting and make the judge curious about everything. The last but the most important point, which I feel should be done in the argument. My friends, normally while arguing a matter, we always, read the depositions of the witnesses, and then we try to explain to the court. Now, before arguing any matter before a judge, you will have to know that judge. Unless you know that judge, no matter, know in the sense about his background or anything, that how a judge loves to listen to a matter, what he likes. He likes to, he is mostly on facts or he's on law points. He likes the arguments to be done in detail, or he is smart enough to understand if you just bring that particular point to his notice. So you have to understand a judge before you argue a matter before him. And then if you understand that, you will immediately adapt to the particular uh, working of a judge, and then you will argue in that particular way. Then, my friends, there is always one thing: the prosecutor is the first to argue, and then you are the second in line to argue, and thereafter he replies to your arguments. So while arguing, there are many of the times nowadays I have seen that the judge, these are the kind of challenges I have been talking about. The judges refuse. They say, you have taken enough time, mister. What do you want to reply again? I am not giving you any more time to reply to to the reply given by the prosecutor. This will be unending. So see to it that while arguing a matter, you have to understand that after your arguments, the prosecutor is bound to reply to the points which you have argued. And therefore, in your arguments, you should always include one important part, and you should say that, my lord, this is the point which I have raised, and the prosecution may come up with this explanation, and therefore I feel that this also should be taken into consideration. So that will, firstly demoralize the prosecutor, because he is just waiting for an opportunity to come up and stand and say, no, no, this is the answer to his query. So firstly, it demoralizes the prosecutor to reply it. And secondly, if a judge is of a nature who is not going to allow you to rebut the reply by the prosecutor, then it will help you a lot. So the sum and substance of all this is that you have to be thoroughly prepared for the argument. During the course of my discussion, I forgot one important thing. While preparation of a trial or a case, when you are dealing on facts, my friends, I don't know how that slipped my mind, but when you are preparing and going before a trial, you will have to read the provisions under which you are going to be charged. So one important aspect is this, that you read the ingredient or the charge and the ingredients of the charge, or the sections of the offense. And then you divide those ingredients into part. Like if it's offense under section 307, the intention and the knowledge you had, whatever may be the ingredients. Now you will have to separate these ingredients of an offense: intention and knowledge, injury, whatever the ingredients are. And then you will have to read the charge sheet in that perspective, as to what are the materials what is the material which is brought by the prosecution in order to prove each ingredient. Now this will help you a lot. Now there are so many legal formalities, like if it's a government servant, sanctioned under section 197. If it's often under section the Prevention of Corruption Act, section 20, again there is a sanction which is required. So many other things are there. if it's a offense under the there are so many other offenses like technical offenses where the scheduled caste and scheduled tribes are involved. In that particular offense, the investigation is to be carried out by an officer not below rank of a deputy superintendent of police. So you will have to understand these legal aspects also. So when you are preparing for the case on facts, you will have to prepare the case on law. So you will have to know where you stand on law. You know that these two ingredients are missing, and I need to exploit these two important aspects. These are the three important things which the prosecution or the investigating agency was supposed to do, and they have not done it. And I have to capitalize on these three important aspects. So while preparing a case on facts and on truth, will have to also prepare your case on law and the directions given by the law. And therefore, my friends, this is how I feel the lawyers, the aspirant, the young lawyers should deal with the different challenges they are facing while conducting a trial. No matter how many times or how many different examples I give, the fact remains that it is the wisdom of that particular lawyer, how wise he is to understand the facts and the circumstances of the case, the people involved in that particular in those transactions, it all depend upon it. And therefore, my friends, I just shared my thoughts with you as to how to deal with a criminal trial and what are the challenges which a lawyer can face. And I thank the Bar Council of Maharashtra and Goa for giving me this opportunity to put up my thoughts for your perusal, for your understanding. And I thank the president, the chairman, the vice chairman, who I can see on the screen, uh, Jain Jaibabe sir, who has been always an inspiration to all these young lawyers and also the Bar Council members. Advocate Satish Deshmukh sir, who is a member of Bar Council of India. First of all, for arranging this CLEP program and also giving opportunity for the young or the junior lawyers like me to put up their thoughts before you. Thank you very much. At the end of it, I would just like to mention that, I have seen so many lectures where normally people deal with the provisions of law. Young lawyers ask questions as to the provisions of law, Section 27, dying declaration, this and that. But I believe that by giving you citations, different judgments, and quoting the different provisions of law, I am going to make you handicapped because you will get used to listening to these lectures and then noting down these judgments. And whenever time requires, you will just go to that judgment, you will go to that provision and do it. And this is my experience, I'm telling you. Unless you do your own research, I don't think anything can help you. You will just note down and then you will become a slave of those lectures and those rulings and those notings, whatever you have made. No, my friends, you will have to do it on your own. So if you are planning, I don't know if there is any question answer session. If you are planning to ask me a question on a particular section, I am not going to answer on any. If you want to know any strategy, if you want to know a thought, what I think about a particular aspect of a case or a provision, yes, definitely I'll answer your queries and your questions. Thank you very much for giving me this opportunity. Over to you, coordinator.
Yeah, yes, sir. We have filtered the question accordingly.
Yeah.
So the first question is, sir, after the direction of Bombay High Court regarding CCTV installation of CCTV footage, so is it advisable that that the CCTV footage should be obtained under the RTI, or whether it is possible to get those footage under the RTI?
So, do you mean to ask this question about the CCTV cameras being installed in the court or generally?
No, no, sir. I'm talking about police station. Now that there is a direction by Bombay High Court that police station should have CCTV footage camera, and the footage should be maintained for a certain period of time. So, is it possible? Number one, is it possible to get the footage, particular footage under the RTI? And and then that is how to benefit the accused.
Okay, I'll tell you what. See now, as per the um Amended Evidence Act, the definition of document has been the scope of definition of document has been enlarged, and documents includes electronic data. So according to me, if it's a electronic data, then it's a document. And then if it's a document, then I've already told you, section 91 of the Code of Criminal Procedure allows you to call for any document which is in the possession of the police or any government officer. So now, if the footage is a document, it's an electronic evidence, then we can always call for those documents in form of electronic evidence by making an application to the court, whatever under section 91, and then you can also call the witnesses under section 311. That also can be done.
Sir, while on 91 CRPC, there are questions regarding at what stage shall 91 be invoked? At the time when the prosecution evidence is going on, or when the accused is examined under 313 and then asks a question, do you want to examine somebody?
See, the wordings of section 91 are very clear, and I'll just read it out to you so that you know. Yes. Whenever any court or officer in charge of police station considers the production of a document or anything is necessary or desirable for purpose of any investigation, inquiry, trial, or other proceeding. So you have to understand this. It includes what? For investigation, inquiry, trial, or other proceeding. So it's quite possible that you are arguing a bail matter and you are taking a plea of alibi, and it is not in my possession. That particular CCTV, I was not there and I was somewhere else. And that particular place is a government officer. So you can definitely make an application to section 91 to prove your innocence even at the time of bail. I had made such an effort, but it was not under section 91. My accused was at a different place at a shop, and I just requested, made an application to the court that the police should go and investigate there. And accordingly, the court ordered the investigating officer to go to that particular shop where he was present and collect the CCTV footage and give a report to the court, and accordingly the officer gave a report. So this can be done.
So the next question is regarding cross-examination, basically suggestions. So what is the effect of suggestion, and if suggestion is not given, what will happen?
This is a wonderful question. Actually, I wanted to, because for want of time, I did not. See, I'll just give one example. Giving suggestions is a very dangerous job. I don't know whether people realize this or not. But when you are giving suggestions to a witness, let us take, for example, a wife of a person who has been brutally murdered is in the witness box, and you tell that lady that what you are telling, whatever you have told is false. This is false. The expressions given by that lady are the most damaging part to your case, because the judge who is sitting on the dais is minutely observing the suggestion given by you to that lady and her response to that suggestion. And when she emphatically denies that and tears come in her eyes, then some sort of confidence is given to the prosecution case, and it has a lot of bad impact on the case of the defense. And therefore, while giving suggestions, either you have to be very soft, or you can tell the judge, Your Honor, I just don't want to waste the time of the court by repeating each and every question, what a sentence said in the chief examination. I just want to deny this fact, this may be recorded. And nowadays, with the computer typing and recording of the evidence, it is seen that that particular part of the evidence in chief examination is copy pasted, and it is written out that is denied. So it's very, very dangerous to just keep on giving denials at random. While giving denials, be very specific, be very gentle, but at the very same time, when a witness is a liar, when he's lying on it, you have to be emphatic, and you have to tell in those words and in that tone that you are lying on this particular fact, and that will impress your case upon the court. This is my way of looking at it.
Thank you very much, sir. We have flood tons of questions, but due paucity of time, we cannot take all the questions.
Yeah.
We express our regret to the participants. So now I request Advocate Sujana Jadhav, madam, to express vote of thanks. Over to you, madam.
Yes, friends, it was indeed a great brainstorming session and guided by Advocate Sangram Desai, sir. Sir has explained provisions related to criminal trials, such as summons, Panchanama, station diary, muddemal, search, and how to conduct cross examination of witnesses, what to ask him, what must not ask. Sir has covered all the provisions from investigation to argument and explained all it in a very easy manner. Sir also explained challenges before criminal trial. This surely is going to help all the advocates in their day-to-day practice. Once again, thank you, sir, for all your time, knowledge, and this informative session. Tons of thanks.
Thank
Over
you.
to Sujit.
Thank you, madam. So, friend, that brings us to the end of today's session. We once again thank Sangram Desai, sir, for sparing his valuable time. So now, as for those who have joined late, let me make announcement that Mar Council of Maharashtra and Goa has decided to continue this program for the entire week. Next week, commencing from Monday. So we have lectures from Monday till Saturday. I'll quickly give you the details of the program. Monday at 11 a.m. we have lecture of Honorable Shri A.N.S. Nadkarni, Additional Solicitor General of India. His topic is jurisdiction and lack of jurisdiction. Tuesday we have lecture of Datta Prasad Lavande, former AG and former chairman of Bar Council of Maharashtra and Goa. His timing is 11 a.m. to 1 p.m. and his topic is pleadings in temporary injunction matter. Then Wednesday we have senior counsel from Bombay High Court, Shri Prasad Dhakepalkar. His topic is challenges in legal practice during COVID and future of virtual courts. Then on Thursday, we have lecture of an eminent speaker, Shri Shekhar Nafde sir, Senior Counsel, Supreme Court of India, and his topic is impact of constitution law on in criminal law, 11 a.m. to 1 p.m. And then Friday we have a lecture on medical jurisprudence by a renowned speaker, Shri Sushil Atre, advocate from Jalgaon. And then on Saturday we have a lecture on by Dr. Dinesh Rao on the topic of uh, forensic science, basically on the aspect of PM report and types of injuries. So this is the from Monday to Saturday, 11 a.m. to 1 a.m. And the as many I have heard, many I've seen many queries. See, there is no official WhatsApp group. All the members of BCMG and the coordinators, we are just forwarding the links to all the groups, and then from there you will get it. Since it is difficult to have a club group of thousand, we have almost 1,000 people every day, so can't have a one group. So just be vigilant about the this thing. I've already stated the link will be shared in advance. Thank you for your participation, Chairman sir. With your permission, we are ending this meeting. Okay. Stay safe, everybody.